have to say that I don't lose any sleep at all about terrorism and the threat to myself. I was unclear how much terrorism there might have been in Australia since September 2001, how much terrorism had been stopped by the existent legislation, and realistically how much terrorism this metadata capturing you're talking about might be able to stop. And really, if I was setting out a program to deal with this, I'd get a 15-year-old hacker and put a bounty on finding terrorists, because they seem to be quite good at fishing out all sorts of data from the internet.
Now, George, do you want to talk about what do we know about who the police have caught, and what tools did they use, and were they the ones we gave them?
Well, we can say a few things about the threat of terrorism. One is we have the alert system in Australia, and we know that the threat to Australia is medium. And until a few years ago, if you went to the government's website to try and understand, well, just how endangered are we, the website said a medium level of threat means there is a medium risk of an attack. And obviously it didn't take you very far in understanding, and I and other people made speeches about that and saying what a silly system it was, and it's now been changed. So if you look at the alert system, medium means that a terrorist attack may occur. And that's all we've got in terms of clarity of the alert system. They're having white papers and other things, and of course a number of speeches, and at the moment the Attorney in particular is making a lot of speeches about the threat posed to Australia by people who become jihadists, potentially in Syria and Iraq, and that's something I've looked into in other countries as well, and personally I can see there is a real threat there. If you look at the dangers of homegrown terrorism, it tends to arise in contexts where people have been radicalised by some form of process, they've had access to training and access to networks, and those are the things that suggest that there may well be a real threat there. As to whether the laws are sufficient, the laws have already been quite strong in actually enabling many prosecutions. We've had 38 people in Australia tried, or at least arrested for terrorism. 26 have been convicted, and all of those people have tended to be convicted at the very early stages. They've bought some explosives, they've developed the beginnings of a plan, but none of them have got anywhere near actually carrying out an act of terrorism. And what that's showing is, in fact, the laws are working in terms of identifying people through surveillance, enabling those people to be prosecuted because they're carrying out acts preparatory to acts of terrorism. And what's not clear to me is why that regime won't equally apply to people who might return from Syria, who can be subject to surveillance and prosecuted if they take even one act. Possess a thing connected to terrorism, and they can potentially be charged. So I see a threat, but I see the laws as being incredibly strong, and also say many of the laws have never been used because they're frankly not needed. So prosecution has tended to work, surveillance has tended to work. The idea of ASIO detaining people for a week, well, they've never used it, because if ASIO starts disappearing innocent Australians, you can imagine what damage it would do to the organisation. So it probably will never be used. The idea of preventative detention orders, whereby you can only ring up your spouse and say I'm safe but can't be contacted, never used, probably never will be. So they're sitting there, and let's hope they're never used, but frankly we're better to get rid of those and really focus on the things that the evidence have shown actually do work, but calibrate those more appropriately to the threat.
And I think just to add to that, it's a shame really that there's so much secrecy around the foiled attempts, because that would actually, I think, help us make an informed decision about how we feel about updating these laws and expanding them and changing them. If we had a full picture in front of us about how they have helped in the past, what events they have managed to curtail. But I think it's very much the surveillance laws and the holding people for what seem to be very long periods of time without needing to arrest them that are probably the most impactful, rather than the proposals around data retention, which I think are more around just helping to facilitate investigations rather than actually nabbing terrorists and getting them off the street.
Question here?
I have 2 points to make. First, about the illogicality of our laws. I run a smoke-free organisation. I'm a child of Bugger Up, and I'm very proud of it. But the government's watching us. I think they don't really like us because we're trying to curtail some smoking. There's an illogicality about that. You you can't smoke in a theatre in the audience, you can't smoke in the lobby, you can't even smoke within 4 metres of the outdoors, the outside of the entrance, but you can smoke on stage for hours. And in any stage in Australia. So I'm just pointing out the illogicality of that particular, of some smoking laws. The main thing, though, I want to know is who's watching the watchers. Do you know, George or Samantha?
Yes, and in terms of who's watching the watchers, I mean, we have some very good people and some good agencies involved. The Inspector General of Intelligence and Security has what you call roving Royal Commission powers to investigate ASIO, and we're very, very strong. But of course, we have to you have to trust that person to do the job, as we don't get access to that information, so we just hope the government appoints credible people, and to my knowledge, the government has. All governments have been very cautious in appointing that person. It's always a risky thing when you're really depending upon a person being the right person and doing a job that you can't actually watch. There's also been an independent monitor of anti-terror laws, Brett Walker from New South Wales, who's had a job of looking across all of the laws and has done an incredible task of looking across all of these statutes to work out, are they needed, are they useful? And what he's done in 4 reports is actually looked at those laws in light of the secret information of the agencies. He's got access to all of their information, so he can look at their case files, how they're actually using these in practice, and make a decision based upon that. Are these useful? Are these necessary? He's got a very long list of things that need to be done. Many of them are just sensible small things, some tightening here, improving the ability to access technologies and the like. But in many cases, Brett Walker has found actually these things just aren't required. He said that some are dangerous because they set precedents within a democracy for detaining innocent people without charge and without adequate justification. Others simply infringe basic free speech rights without any justification. Others are dangerous because actually they are likely to radicalise the very communities that we need to cooperate with us. If particularly the Muslim community has a sense that they're being unfairly targeted. The last thing we want to do is create a victim mentality in that community, because you break down their willingness to cooperate with agencies, which is one of the most important ways of preventing terrorism. I mean, it's much more effective if somebody, if you like, informs and gives you the information than just hoping you pick it up through surveillance. But Brett Walker was so effective that the response of the current government was to abolish his position, rather than actually adopting his recommendations. And it was a fascinating exercise in government speak, because they essentially said he's done such a good job in identifying these problems, and the subtext was, we really don't have any intention of actually doing what he says needs to be done. It's better to abolish the office than have this permanent embarrassment around showing us where our laws are flawed. That led to a very significant outcry, and Cass and others wrote good articles. The government has backed down on that. The government says now the resources of the office will actually be increased. But Brett's position expired in April of this year. No one has been reappointed. So they've committed to keep the office, give it extra resources, but nobody's holding the position now for many months, and there's no suggestion that person will be appointed during the life of the debate on the new laws. That is a real problem here, because the person who would be the most effective in this debate, given their access to the information and ability to independently help the community understand, actually is not there at the moment.
Now, if I get a couple of questions, excellent. I was about to say, I know enough of you to call you out and nominate you. Come over here.
Look, David Haddock's my name. I'm actually a telco professional, and I find it extraordinary the data retention piece has now been going for about 4 years, which is when the AG's department first started talking to industry, and they may actually have found the issue a lot easier to handle if they'd not had this obsession with secrecy of all these meetings being held in secret about what it is they want to do. But I have a sort of a proposition. The issue about data retention often gets confused because it's not actually primarily used. Accessing retained data is not primarily used for the purposes of investigation, but it's more used for the case of making the case stick. So it's where I've figured out who the person was, but I need to make the case beyond all reasonable doubt. Data retention helps me identify where the person was when. And so many cases have hinged upon the telephony data. But the interesting point is that the data has never, ever previously been retained for the purposes of law enforcement. There has always been opportunistic access of existing data, and it's a real concern to suggest that we've now got a regime being proposed exclusively for the purposes of law enforcement, as opposed to accessing something that already exists. But my question is for George and for Samantha. One of the concerns now is that we've got all the functions reporting to the Attorney General. ASIO reports to the Attorney General, but the Attorney General's department is also in charge of making all these laws. In the data retention space specifically, and the whole interception regime actually used to belong to the Department of Communications. And so there was at least a process inside government of one agency, one department having to convince another. What is very clear today, and it was very clear unfortunately under the last government as well, is the AG and the AGD have become captive of the agencies. And it's crazy that we've now got this concept that says the Attorney General is also the Minister for Justice. The Attorney General has historically been the man responsible for the running of the courts, not the running of the investigative services. And question for both Samantha and George, is that one of the things that perhaps we should be pushing for to get this greater focus on whether these powers are in fact required?
Want to kick off, Sam?
Yeah, absolutely, David. And the more checks and balances that are in place, and the more sanity checking that's taking place, the better. Absolutely, in my view. And we've seen evidence on this issue and others recently that the Attorney General and the Minister for Communications aren't talking as much as they should be.
Yeah, look, I agree. I think you made some really good points there. And I think at the beginning you identified the secrecy. You wonder whether the secrecy is there to just obscure the fact that there's just a lack of clarity, that they don't quite know what to say in public. But that in itself is deeply concerning, to have made a decision to go down this path without a very clear understanding of the path we're going down. That is, we've made a decision to regulate without understanding what we're proposing to regulate, is deeply troubling. And you're really putting the cart before the horse in this area, I think. And without, it seems, a very clear understanding of the cost to industry that might go with that, which it's obviously hard to quantify when you actually know what needs to be retained, except we've just got this 2-year period, but some sort of subset involved. Subsets can be large or small, who knows. But on the question of the Attorney General, look, I've been concerned for some time that the Attorney General in Australia has developed really into a Homeland Security Minister. If you talk, as I've done, to attorneys over the several years, they will very vocally complain about how much of their work takes up doing the ASIO work and the national security work. And it's entirely appropriate the Minister does that work. You want them to be doing it, but when it's all internalised in that department, and in particular the attorney is normally meant to be the voice within Cabinet raising questions about the appropriateness of the laws that are being enacted, you remove what should be a very healthy tension within government between AGs and Homeland Security. And I think that is a real factor here. I'd say more broadly, the fact that we don't have decent human rights protection for freedom of speech, privacy and other things is very telling, because even if you do have an attorney who's very willing to defend those rights, in the end there's actually not much to defend because they're not legally protected in Australia. They really are dependent upon political will more than anything else, and we know the will is often not there to do so.
Across this question?
Yeah. My name is Brad Rowe. I've worked for the government for quite some time, and as a lawyer, I seem to have identified a phenomenon which I call demonstrative legislation, which is when governments slap laws onto the statute books more as a sort of public relations exercise to assure a particular constituency that whatever problem they've got is being addressed by the government. So they just draft this stuff up, put on the books. Whether it actually gets enforced, whether they actually supply the resources to enforce it is almost beside the point. We just put this on the books to make it look as though we're concerned and we're doing something about it. Is there an element of what I call demonstrative legislation about this process? Is it perhaps just a PR exercise? I don't know.
Look, I can start. I think you're absolutely right, and of course it's a very common feature in politics in Australia. And you need to look at the law and order debate at the state level to see how much of lawmaking is really about political posturing and sending signals about what you stand for, how you're tough on crime, how you've identified a group, and in particular if it's a group that causes fear and grief in the community. Well, there's really no limit to what the community is prepared to authorise you to do while in the grip of that. And that's why when you look at the making of Australia's anti-terror laws, uniformly they have coincided with a level of fear in the community post-September 11, post-Bali, post-London bombings, and now indeed at the moment the government is doing its absolute best to magnify the fear connected with Syria and Iraq. And there certainly is a genuine problem there, but it's by no means the most significant national security problem Australia is facing. And there are many others of even greater magnitude that just don't get a look in. I think what it also demonstrates in this area is just how much of this is reactive. There's very little in the anti-terror space where we sit down and think, what state does the law need to be in? What are the appropriate laws that need to be passed? Where are the gaps? It tends to be more, we have a threat, we've got to do something. We must be seen to be acting. In fact, there are enormous political advantages for both sides of politics to be seen to be acting, to dealing with a national security problem. The more you can talk it up, the better you get seen as a result. And that's a bipartisan advantage. And this area is very, very susceptible to those problems, and it's a large part of the explanation for why we have such an extraordinary number of laws, why they often reach further than other laws, and why there seems to be no end in sight. Because if you're a government, I mean, this is a gift, this sort of stuff. Why would you stop making these laws, whatever the justification? Because you get lots of brownie points in the community for doing so.
Thank you.
Sam, I was going to ask you if you could expand a little bit on why the European courts tossed out their version of these powers.
Yeah, well, the European directive is very similar to what we have seen here, even down to the lengths of time. In Europe, there was a minimum retention period for certain types of data, being 6 months, and other types of data for up to 2 years. And that was enacted back in 2006, so what's that, 8 years ago now. And as with many European directives that involve human rights issues, there was a lot of disagreement within the Union from certain member states like the UK about how to implement this directive. So it was a little bit controversial from the start, Cass. And again, I think a lot of the arguments were being made by the target industry of, look, we already work with the law enforcement community. We already provide this data. The relationships work well, they're smooth. Occasionally, yes, data's being requested that we don't have anymore, but generally speaking, the relationship is working well. Why do we need this? And there's obviously a very strong legacy for human rights protections in Europe, in particular around privacy. So there was also that additional lens being looked through when the public were thinking about data retention and access to data more broadly. And I think back then, there wasn't really a level of awareness amongst the public that this kind of data was being collected by companies, let alone that it was then being shared with law enforcement officers on the basis of the right documentation being produced. But I think there's just been a really interesting tide change, Cass, in Europe, where there was a lot of fear around 9/11 and of course the bombings in Spain and then in London. And a lot of, I think, a sense of, okay, we just have to live with this now because this is a brave new world we're living in. We are at risk. There are threats. And we just have to put up with this invasion. But I think the tide is turning now and people are thinking, actually, we've made a lot of progress. We think maybe some of these measures are a bit draconian. We've had WikiLeaks and, the whole NSA Snowden revelations happen in the meantime. And I just think people have become a little bit more skeptical now about powers and surveillance, and they're starting to ask these questions and think, actually, have we gone a bit too far? We need to wind this back a little bit.
You have a question over here?
For George, I find the whole notion that e-organisation can be regarded as something to be curtailed. What happens if a government decides, we don't like CIS or IPA or the climate realists, and they get shut down. They're of course not terrorist organisations, but they do have something to say that more socialist governments wouldn't be particularly amused with. Another area is the criticism. You write a comment about your treatment of you by ASIO, landing 5 years in jail. That's a case of to silence criticism is to silence freedom. It all sounds like it's gone way too far to me.
It's interesting. How far does the sedition powers potentially go?
The potential for abuse is astronomical.
Look, the potential is very large. I mean, one of the most troubling aspects of these laws is just how they can lead to jail for people who reveal government wrongdoing or incompetence. The new proposal that if you write a journalistic article about a secret operation that ASIO may be running, I mean, it may jeopardise the operation. There may be circumstances where you shouldn't be able to write that article, but it's a blanket coverage, and you can be writing an article that's absolutely in the public interest, and you can still be jailed. And that's really deeply troubling, and that runs pretty counter to what I would have thought are some of the most basic precepts of how democracy should work. You couldn't have a law like that in the United States, the UK, Canada. In fact, they don't have laws like that. Australia is really exceptional in this regard. And again, it comes down to the fact that we're the only nation amongst democratic nations that doesn't have strong free speech protection. So when we come to the terror law area, we want demonstrable laws where we act. There's nothing to stop our parliaments actually saying, yes, we will restrict freedom of speech in these areas, and there's actually not much you can do about it. The politicians have got a blank check in this area. You also raised the issue of organisations. Look, that's a very broad power on the part of the attorney, and it means that you can ban organisations of a few types. One is the organisation itself is preparing or engaging in terrorism, and you can imagine it is appropriate to disrupt organisations where they're actively engaged in terrorist acts or they might prepare for it. That seems absolutely appropriate to me. Questions about whether the attorney should be doing it or whether some other person should be making that decision. But unfortunately it also extends to banning any organisation that advocates terrorism. So again, merely for the speech. Now, terrorism is so broadly defined that it covers any act of violence undertaken for a political, religious or ideological cause where you're trying to intimidate or coerce a government. Nelson Mandela, absolutely a terrorist under Australian law, no doubt about that. He undertook bombings in South Africa for an ideological cause, get rid of apartheid, and he did so to try and coerce the government, get rid of apartheid. Absolutely a terrorist under Australia's laws. Those people who are fighting armed resistance against despotic regime are absolutely terrorists. There is no distinction in our laws for freedom fighters. Anyone who undertakes violence for that ideological, political or other motive, however justifiable you may think they are terrorists under our laws. So your organisation can be banned if you actually praise one of those acts of a freedom fighter that you may think is appropriate in whatever moral context you may be talking about. And that organisation can be banned, every member can be jailed, and again, purely for the speech. And you can be jailed even if you disagree with the speech of your organisation. So members are jailed irrespective of their agreement or not. It's an extraordinary power. It's never been used because it is so extraordinary, but I fear it might be used, and indeed one of the proposals the government is introducing is they want to expand the ability to ban organisations to go beyond advocacy, so for glorifying terrorism or saying things that might encourage people to engage in terrorist acts. And I'm deeply concerned about jailing people for their speech alone in any circumstances, though sometimes it might be justified for acts of inciting violence. But, for these sort of ephemeral things of just belonging to an organisation that says something you don't agree with and you being jailed for that, that seems way out of kilter. Yet we're actually looking at expanding that in the laws coming into Parliament in a few weeks.
Another question on the other side?
Sorry, I'm going to continue not to introduce myself in case someone's listening. Just trying to hone down on those 30 convicted?
38 people arrested, 26 people convicted.
3 a year. You seem to imply that maybe a lot of those had to do with conventional policing efforts and not much with surveillance. Can you try and quantify for me just how much of a difference the surveillance bit might be making? That's part one of the question. Yep. And part two of the question, If these laws go into effect and one is a terrorist, for example, would there not be some fairly easy technological hacks to get around the surveillance umbrella? I would have thought. Do you have tech guys that you've talked to? Can they buy cheap disposable mobile phones and run cells doing things that way? And will these actually work?
Sam, you might want to lead off. You're the expert, although I'm sure you never do, in getting around official tech.
Well, there are certainly ways and means of encrypting your communications. So the law enforcement community hate Gmail because it's all encrypted. So yeah, it's a word to the wise. If you're not using Gmail and you're worried about your communications being intercepted, think about that. Skype, similarly. So with a lot of emerging technologies and communications platforms, the ability and in fact the necessity to encrypt has become a really interesting policy decision that companies are making, particularly a lot of the bigger companies who have been alleged victims of unauthorised government surveillance.
So in terms of the prosecutions themselves, so these 38 people, one thing that's interesting is there's been almost none for the last 5 years. So almost all of these prosecutions, I think bar one, said all occurred before 2009. So there's been a very big drop-off, which either means that indeed the threat has lessened significantly, or people are getting the message that the authorities have the capacity to identify you quickly. The people who have been charged and we've had trials, almost completely the evidence against them has been based upon telephone intercept evidence and other electronic forms of interception. So this sort of data is crucial in terms of putting them in a particular place, in talking to a particular person, and then separately a warrant is going to actually listen to their conversations. In fact, the trials tend to consist of days and days of listening to conversations where these people talk to each other and say, we should think about bombing this or buy some fertiliser or something like that. These are at the very early stages, so in the most cases no plan is ever formed, but nonetheless there is evidence of genuine preparation. These people could certainly take steps to avoid being caught, but they tend to be unsophisticated young men, and they're all men. They tend often not to have a very high level of education. They tend to be extremely angry about Australia's foreign policies in particular, and the invasion of Iraq was the number one, if you like, incitement to undertaking many of these acts. And these are ill thought out actions that haven't actually led to the development of a plan in any event. So I suppose if you wanted to be more sophisticated you could avoid it, but these tend to be hot-headed young men who don't think about the consequences, and if they did, well, they'd stop pretty quickly because they would realise that these 25-year jail terms these people are facing for telephone calls and sometimes the buying of equipment.
I'll come back to this side.
Yep. Hi, George, you were saying earlier how there's not really much scope for protections of various, free speech, freedom of association, etc. I'm wondering what scope is there for the court system to interpret the laws that we already have relating to national security in a way that is favourable to civil liberties? Is that realistic? Is that a possibility?
Well, the courts have certainly developed approaches that mean that if there's ambiguity in the law, there's a grey area, and sometimes they can make a choice more protective of freedom of speech, let's say. So they can make choices where choices are available, but that requires a grey area in the first place, and these laws are drafted very explicitly. Say something and you can be jailed for 7 years. There's no ambiguity there. So in the end, unless you have something far stronger, like a right in the Constitution that can override it, there's actually very little the courts can do. They can certainly ensure a fair trial, and I think one of the admirable things the courts have done is give the men charged with these offences fair trials, and that's been incredibly important that that's happened. But in the end, Australia is the only democracy now in the world that doesn't have a Bill of Rights, and it's very telling when it comes to our anti-terror laws. And I mean, I often am invited to give speeches overseas because people are very interested in our anti-terror laws, and the question they ask is, how did Australia pass those laws about free speech? How could, our perception of your country is very different to these laws. How did this happen? And the simple answer is there's not the legal checks on our politicians that you find in those other countries. So at that time of lawmaking, where those checks aren't there, our politicians went much further than George W. Bush or anyone else in comparable countries.
One more over here.
Thank you.
Peter Hindrup. First, having worked in advertising, they've dreamt up terrorism. They came up with the best idea ever. It is endless. You just have to get out there and say there was a threat, we found a bomb. People talking about a bomb in this story all up again. This is going to go on for the lifetime of everybody here. Anybody here, the oldest here. That's one. Two, as I recall, the last people that I can got convicted here in Australia, I think there were 3 people, and the reports were that they had been under surveillance and planning for 12 months to whatever they were going to do. Well, anybody who's planning for 12 months, leave them there because they're not going to do anything. If you were going to do anything like this, you would do it in 3 to 6 weeks, right? To finish, if you're going to get rolled away and jailed for ideas and talking about, when I was young and we were in coffee bars, they could have just grabbed the whole coffee bar and shoveled them off forever and have us still bricked up. Thank you.
I'll wrap up the next couple of questions into some closing remarks if I can. Do you want to give us your question?
George, I'd like to ask you, or to tell the people here about so-called threats to liberty which occurred in the past. And I mentioned the case of Mr. Lance Sharkey. Mr. Sharkey was General Secretary of the Communist Party of Australia. He was asked a question by Alan Reid, the editor of the Sydney Daily Telegraph, and he said, look, in the event of Soviet forces entering Australia, what should Australian working people do? And naturally and rightly, Mr. Sharkey said, look, I don't see that happening, but if they did, then it would be the duty of Australian working people to assist Soviet armed forces for an aggressor. And that was the emphasis. For that he was sentenced to 3 years in prison. And then in Queensland called Burns was thrown into prison for 6 months, saying something similar. And those of us who were in the Vietnam moratorium movement, we were well and truly under surveillance by ASIO. And yet, in spite of all of that, and we've got the stuff under freedom of information, we have no regrets about it, and indeed we have been vindicated. But the Americans said at the time that the Viet Cong were the terrorists. Who was it doing the terrorising in Vietnam, George? So I'd like to hear what you've got to say about people have lost their jobs. People have lost their jobs in government departments because they've got the wrong politics.
We'll come back to the broader application of charges of sedition. One more over that side and one here, and then I might invite you to weave these themes into your closing remarks.
Graham Greenleaf. Back to the question of metadata, and as one of the gentlemen from a telco said, its collection has been largely opportunistic at this stage, and the Privacy Act even has some inhibitions in it against retention of such personal information for longer than it's needed. But it does strike me that having a data retention law, as has been said, makes that collection, formal for the first time. And what I'm interested in is the slippery slope issue. That it's quite possible that the definition that'll come up this time will be only for a very narrow definition of what is metadata and perhaps for a very short period of retention. But as is the habit with such laws in Australia, both of those aspects will be expanded very easily as time goes on, particularly if the definitions are able to be amended by regulations. The regulation powers are the ones we always need to watch out for. So I'm just interested in your comments on that. And also, back to the question you were asked about who watches the watchers, I don't think I've heard any mention this evening of the Privacy Commissioner. And if you look at questions, the metadata being kept at government behest for investigative purposes, well, once it's kept, then its potential use by the private sector also expands. if the retention of it's expanding, well, the use of big data for private sector purposes becomes more attractive and more possible and more legitimised. And it ought to be the Privacy Commissioner who's the person who takes the big picture view of the relationships between private sector and public sector uses. But we don't seem to be hearing that, and we don't really seem to hear anyone even expecting the Privacy Commissioner to say anything useful on this topic.
Well, another question there is about, I guess, the governance, and also are there principles that we can fall back on to deal with some of the scope creep problems? Our last question here.
That's nicely leads on to my question, which is about the hysteria that people suffer over these proposed laws about retention of metadata, when the very same people will quite voluntarily agree to hand over far more data to private companies, particularly social media, Facebook, Twitter. Google know more about me than I do. If you take an application such as Find My Phone, which maybe some people have here, and you can do this at home if you want to. You don't actually have to lose your phone, but you can get it to take a picture of you and find exactly where you are, your GPS coordinates. I'm probably scaring cat. I'm doing the one scaring cats now. And we voluntarily hand over that information to private companies, yet get hysterical when we're talking about metadata. Is that more down to people's ignorance, or is that down to a healthy distrust of government?
I would say one thing to cheer myself up and hope it cheers others up. Stacey over here did the Who Does Google Think You Are test, and apparently she's a 20-year-old black man. So happily, Google doesn't know everybody as well as it thinks it does. So if you guys could wrap up some of those philosophical and practical concerns in your closing remarks, that would be terrific.
Okay, well, I'll start if you want and let you finish. I mean, look, some really great comments and questions there, and I suppose we started, Cass, with Who Does Google Think You Are? I'm not sure whether to be amused or really disturbed, because it shows the problems with some of this data as well, that we are drawing very significant conclusions about people, including in a investigative criminal sense, based upon data that itself can be deeply flawed or difficult to analyse. And I was very taken with Graham's point as well, that we've missed the larger part of this debate sometimes, and that's the private sector angle. We can say that wasn't part of our brief, but I think in terms of the slippery slope, that's a very big concern about if this data exists, how might it be used? I wonder whether it's a slippery slope or more just a vertical cliff, given where we stand at the moment. But I'd say more generally to some of the other things, look, yes, I mean, we had comments there about the prosecutions of Burns and Sharkey going back a long way, and what that demonstrates is these issues aren't necessarily old issues. The capacity to drive hysteria in the community, to create fear, to demonise people, to enact stringent national security laws, I mean, that's been around in Australia for a long time. But what's different today is this war on terror has got no conceivable end. I mean, it's a war on a methodology. It's not a war on a particular group, even though certain groups, in particular religious groups, are sometimes identified. I mean, terrorism's always going to be here, and that's what's deeply troubling and needs to force to ask very important questions about just how far do we extend in regard to dealing with the threat that will never disappear, but we know will give rise to ongoing cycles of real concern in the community that can be taken advantage of. I suppose for me that's why it just comes down ultimately into this area that, I mean, if you really care about liberty, you've got to protect it. You can't assume that it's always going to be robust in the face of these pressures. We know it's not, that governments and politicians are more than capable of eroding that liberty, often with great speed and in surprising ways, and I think that one of the reactions ought to be that if we care about those liberties, we need not just to be concerned about the laws that are trenching upon them, but actually to strengthen those liberties to a greater degree in the first place.
You hear, Sam?
Yeah, here as well. Yes, this threat is never going away. We're back in Iraq, for God's sake. And I think that the whole privacy conversation is a really interesting one. When the data retention proposals hit the media threat initially, there was a gasp from the Minister for Communications. He hadn't been included in the conversations, and of course the Privacy Commissioner revealed that he had also not been consulted on these new provisions at all. He's in a little bit of a unique position because, of course, his remit is to be independent of government. So, one point of view may be that actually he's not in the inner circle. His role is an important one, but, question whether he does have a role to play. He certainly would participate in a public consultation. He has done on many of these issues where he sees threats to privacy, but it's a very important issue to think about, and I guess a potential check and balance and recourse for us to remember that he is there to champion how our personal information is being used, at least. This notion of privacy and what it means today is something I spend a lot of my professional and personal time thinking about. Privacy clearly means a lot of different things to different people now. Yes, we have enormous quantities of data being voluntarily shared in all sorts of open forums. And technology companies are collecting huge amounts of data, so much data they don't know what to do with it a lot of the time. And as I mentioned in the data retention context, all of this data is already being collected, so that's not what companies are being asked to do or change by government. This data is already being collected, and I think we have come a long way since the terrorism threat initially reared its ugly head. We are now, I think, a lot more informed about the risks of overreaching legislation and infringements on liberties, and I guess I just encourage you all to take an interest in these issues and to ask questions and to not be afraid to make a little bit of noise about an issue if you feel like more attention needs to be paid to it, or that the government need to hear that actually we're not comfortable with a lot of these moves down a very slippery slope.
Thank you both very much for taking time to talk with us tonight. I would like to end by reminding people that the very first political prisoner who was transported to Australia as a convict was transported here for promoting classical liberalism in Scotland. So, the idea is that we think mainstream now were not always the case, and the protections that we built up to defend people like him may well be at risk to some extent if we don't keep protecting things that we've perhaps become accustomed to assuming don't require constant tending. Thank you all for coming, and we'll be in touch in the coming months with further events and publications on this topic. Thanks and good night.